But right now, time to continue the third part of our three-part series on divorce. Now, we know that divorce, sadly, is not something people love to do. I don't think people deliberately get into marriage to do that. We know also that divorce may be between two people, but the fact is that others are affected as well. Most importantly, children. Now, a couple of weeks ago, we took a look at the general things you need to consider when talking about divorce or going down that path. Last week, we focused more specifically on property. This week, Eva Bailey joins us, and she is a family law specialist who can help us look at how you factor in children and the responsibilities you have in relation to that. Hello, Eva.
Hi, Sonya. Thanks for having me back today.
Yeah, it's good to talk with you again. I guess in the end, things are things, but the most important part of all of this is making sure children are looked after well, isn't it?
That's quite right. Usually children are the priority for our clients and the people we talk to about their separation.
Yeah. So there's lots of factors with divorce, and we know it's a difficult time. Emotions are often heightened. But what's the overriding feature we need to look at when it comes to how we deal with children? Whose best interests are involved here?
Well, that's exactly what we need to look at. Under the Family Law Act, the paramount consideration is the best interests of the child, and that's what we need to focus on, and that's what we talk to our clients about. It's just that going through a difficult time, they often don't agree on that, mum and dad, as to what those best interests are.
And when we talk about best interests, who ultimately determines that?
Well, hopefully the two parents are ultimately able to determine that with some help from mediators or their lawyers and other people like that. But if they can't work that out between them, then ultimately a court will be asked to make that decision for them.
Okay. What are the best interests? Are we talking about where they live? Because sometimes the person who's got the most isn't necessarily the person that gives the most.
That's right. There often is an argument about where children should live, how often they should see the other parent. There's also other considerations like schooling, special times of years, school holidays and all sorts of considerations. The Family Law Act does help us try and work out what are the best interests for children, and it looks at the views of the children, the closeness of the children to each of their parents and other factors like that to try and work out what decision is in their best interests.
So the children are spoken to about this?
It depends on their age, but certainly the children's views are an important factor of what is in their best interests. If they are too little to be spoken to by experts, then it might be the parents reporting to the court or to each other what the children are telling them, and obviously there might be a bias with that, but we need to listen to their views somehow. As they get older, experts might come in to talk to them and to gauge their view for the court or for the parents in trying to work it out.
What weight is given to the child? Now, I'm not saying that we shouldn't listen to the child, but there may be other factors playing in. You get a 15 or a 16-year-old who thinks they might get an easier time of it with one parent than the other. That might be colouring their choice.
Quite right. We need to look at the reasons behind children's views and how they've come to those views, because there can be some influence by parents as to those views. We look at the age and maturity of the children. So children who are under the age of 12 are going to have a say in what happens to them, but their wishes wouldn't be given as much weight as somebody who's 12 and above, and then as they get into their teenage years, their wishes would become more and more important, but in the context of all the other things going on.
Mm. And so when you say we take into account, is that you as the representative or the lawyer for one party and the lawyer as the representative for another? At what point do other people get brought in?
That's right. So we, as with all family law matters, we try and negotiate them, and we write to the other solicitor, or we encourage parents to try and discuss these things with each other or through mediators if they can, or we negotiate through the lawyers' offices, or we end up in court. And wherever we're ending up with it or starting with it, we always try and have those discussions with our client to try and help them be child-focused and to think about what a court might do if you end up in a court.
There's a perception that, I don't know, it may well be the reality, but I'm saying there's certainly a perception that mums are treated better within the court system than dads.
Yes, I think that certainly has been the perception. There have been changes to the Family Law Act deliberately put in place to try and address or readdress that balance or imbalance. There are specific orders now in the Family Law Act, sections that talk about the court must consider equal or substantial time for parents if it's appropriate to have shared parental responsibility for parents. It is trying to address that. The difficulty for the system and the court is that when you look at the closeness of parents to children, and if you've got young children, it just simply is the case that often mum might be closer because mum is the one who's given birth to them, breastfed them and cared for them primarily in those early years. That may not be the case. Each case needs to be looked at on a case-by-case basis, but it still is in our society often the case. The fact is mum does give birth, and if someone's breastfeeding, that's going to be mum. So it starts out from there. So later on, if dad has been a very involved carer, he may ultimately have been the primary carer for children. He should then equally be considered the closest of his relationship as to where the children should be living and things like that.
You're listening to ABC Radio Adelaide, South Australia and Broken Hill. Eva Bailey is in the studio with me. She is a partner at Anderson Solicitors and she is a family court law. Well, she's a family lawyer. Now, maybe you have a question to ask of her. Now, she can't give specific advice, obviously, in these kinds of cases. But if you've got questions about how the process works or some general questions in relation to this that you'd like to know some answers to, please feel free to give us a ring, 1300 222 891, or you can text on 0467 922 891. What's the process then? You talk about those things. Can they be casual arrangements between the divorcing parents of children that are there, or do they have to be lodged, submitted to court and adhered to that way?
Look, absolutely. There's a lot of parents that do agree on the arrangements for their children, and those arrangements can be casual. They can be written down in what we call a parenting plan that the parties write down and sign themselves, and it's just a document that gives some record of what they've agreed. A lawyer can draw that for you also. That's not strictly binding like a court order, so it can be a casual written agreement.
And so why would you write it down in that instance?
I think just to make sure there's clarity about what you've agreed. For example, when you're going to hand over children, have you got a time and a place that you're going to do that? How often is that going to occur? To try to avoid any disagreement about what was agreed in the first place. So
everyone knows the blueprint of
what's
going
right.
on. If you were to change that parenting plan, because circumstances change, that's what life's all about, would you go back and redraw that?
It depends, I guess. Some parties can communicate. They might send an SMS and say, you know, little John's got a school concert to go to. Can I take him to that? Or, you know, he's got a commitment or a birthday party. And some people are able to change that off the cuff like that. Other people need to have it in writing and more formal than that.
Now, a parenting plan is different to a court order, isn't it?
That's right.
What's a court order?
A court order is an order that either the parties agree on and it is made by consent by lodging it with the court, or where parties don't agree and we have to initiate court proceedings and then get a judge to make decisions and give an order to the parties about what will happen.
So under what circumstances would a court order be initiated as opposed to a parenting plan?
Hopefully parties can come to an agreement about what they want for their children, but if they're concerned that they need to protect that and make sure that the other party does comply with that agreement, they might come to us to have that written up as a court order and lodged with the court. Otherwise, if parties can't agree and they need someone to make that decision for them, that's when we would apply to the court for the court to consider it and make orders.
And what weight does a court order have? I mean, if you choose to go against it, either parent.
Court orders are binding and there can be consequences of not complying with the court order. The courts have some fairly wide powers about that. There can be consequences like fines, or in worst case scenarios, they can order jail through our federal court system if you're breaching a court order. That would be in quite a drastic situation.
What if it's just kind of that exaggerated, you know, someone takes longer to return the children than what was agreed, or is making arrangements difficult?
Yeah, it is difficult for the courts to make orders to make people, say, better parents or more child-focused. The court does expect people to comply with their orders, and if someone's not complying with an order, we can bring a contravention applying to the court to raise that breach with the court. We wouldn't usually do that, though, perhaps unless it was a consistent breach or an ongoing difficulty.
1300 222 891 is the phone number to call if you'd like to ask Eva a question about children and how we manage children through the process of divorce. She is a partner with Anderson Solicitors. You can also text us on 0467 922 891. One of our texters asks about the issue of taking children overseas, either to travel or to live. How does that fit within a court order?
Yes, generally speaking, if you've got court proceedings on, you do need to get a court order to take your children out of Australia. You might otherwise just agree it with the other parent if you don't have proceedings on. Where things get a bit difficult is sometimes when someone wants to apply for a passport, you need both parents' signatures for that passport application to go through. And if the other parent won't agree, you may need to apply to the court to ask the court to make an order about granting that passport.
Okay, so that might be for travel, but what about if it was for that more permanent situation? Does the parent have to agree to that, or can you stop the other parent from taking a child overseas to live?
I think the short answer is yes, you can. It depends on the relationship that each of the parents have got with the children. If one of the parent doesn't have a relationship with the children and the other parent is looking at moving them, that's one thing. But if you, by moving children overseas, are stopping their relationship with the other parent, that's something pretty serious that a court would be reluctant to agree to without very good reason for that. There are particular countries that Australia has an agreement with. It's called the Hague Convention. And if a child is taken to one of those countries, our country will work with that country to get them brought back to Australia.
Let's talk about when things aren't perhaps amicable, in particular, when perhaps there are, when domestic violence perhaps plays a role in the divorce, or at least, I'm trying to think of another example, but other issues that might affect the children's safety.
Sure. Look, that is a primary consideration under the Act. So the Act talks about the best interests of the children, and the primary considerations are having a meaningful relationship with each parent, but also the children being protected and safe. So keeping the children protected from family violence is a primary consideration of the courts, and they deal very carefully with those situations, and they act cautiously until the court can determine that the child will be safe.
So in a streamlined situation, it is possible to keep this, for the large part, out of the court system.
It is
if
possible.
If you can agree.
That's right. Yeah.
If you can't do that, is the lawyer the next step, or is there something in between?
You can try mediation through Centrecare or Relationships Australia unrepresented without lawyers, or you can try mediation with lawyers. You can go and see a lawyer to give you some advice, but then go back to the other parent using that advice. You might not engage the lawyer at that point. You might still try to negotiate it based on what the lawyer's told you about the law. You might mediate it, but ultimately, if you can't agree it through mediation or with the other person directly, you're likely to need a lawyer to try and negotiate for you.
It is coming up to Christmas, and just before 3 o'clock we were talking very specifically about the difficulties of Christmas arrangements. Often when you are going through a divorce or when you're separated, that makes things even more difficult. So coming to the arrangements for children at Christmas time, how specific do you have to be? How clear do you have to be?
Yes, again, it really depends on the situation. Some parents can sort it out year by year directly, but often if you're going to have a parenting plan that's an agreement or an order, you will often deal with Christmas in it. That way, everyone knows what's happening. What we find people doing is often sharing the day. I think one of your previous talkers said something about one person having Christmas Eve, Christmas morning, the other person having Christmas Day afternoon. That's often something that people have, and they often alternate that year by year. We are finding that there is a growing interest in not splitting the day. Some people are simply saying, well, look, I'd rather have the full day one year and then forego at the next, rather than having the children move around on that day. It depends somewhat on their family's traditions and the other commitments of their extended family that they want the children to attend.
And I guess we're talking about Christmas, but in different cultural groups, I guess we're talking about the significant days in their celebrations as well.
That's right. We usually deal with a number of special occasions: Christmas, Easter, children's birthdays, parents' birthdays, because if possible, everyone wants to see their child on their birthday. Mother's Day and Father's Day is often something that is specific in orders or agreements.
Or Ramadan or Hanukkah or whatever people might
Exactly,
be
Chinese
marking.
New Year
Yeah.
or various things like that.
Yeah. Things change, don't they? I mean, you might have court orders in place. Someone's attitude changes or their behaviour changes or job changes or whatever. How easy is it to change court orders?
Well, one thing with a court order as opposed to a parenting plan, it is more difficult to change formally. A court order, a final court order is that. It is a final court order. Having said that, if parents agree to vary it and they're happy with that, they can make variations to their arrangement. But if things go wrong down the track, they're likely to go back to the specific order. Sometimes we do apply to change them, but we need to show that there's been a major change in circumstances to have court orders change down the track.
In theory, all of this is looking after kids, but in reality and practice, these things are stretched and broken all the time, aren't they?
Look, that is the reality. At the end of the day, the courts, as I said, expect their orders to be complied with, but people do various things in relation to their children. Hopefully people are acting in the best interest of the children, but it is hard for them to put their own emotions aside and do what is child-focused, and sometimes that includes following the strict line of the orders, and they might stretch it or they might run late or things like that.
I mean, I've got one text here. He says, enforcing court orders, their experience has been that it's utterly hopeless.
It isn't easy to enforce them. The court does have powers to enforce. Really, the court would like people to get along and sort things out themselves, and it just doesn't always happen that way. So we can bring contraventions. Also, if you've got a current proceeding, it's likely to affect your proceeding if you're not complying with the judge's orders, because that's likely to get them offside. But I don't disagree with the caller. It is hard to enforce court orders. You have to apply back to the court and ask the court for a consequence for the other person.
Well, I mean, it's not true in many cases, but if you can sort it out as amicably as possible with both of you having the best interests of the children at heart. I did wonder, within divorce though, and when it comes to children, do grandparents have a role? This probably sounds like a very personal point of view, given that I've become a grandparent this year. But I'm sure there are lots of grandparents out there who, through divorce, often lose access to their children or get access less than they would like.
Yes, quite true. Under the Family Law Act, anyone with a significant interest in the child's life or involvement in the child's life has a right, or the child has a right, to have a relationship with that person. So we do often have grandparents seeking advice and potentially making applications to see their grandchildren. Again, it comes back to the child having the child's best interests to have a right to a relationship with that person.
Okay, so one parent doesn't have the right to ostracise the other parent's family.
No, that's correct.
Or the other parent, obviously.
That's right.
Unless there's
good
other
reason.
issues.
There might be good reason. There might be family
Safety
violence
issues
and
or
things
something
like that.
Mm.
But it's not a decision to make simply because you don't like those people.
Eva Bailey, thank you for hopefully shedding some light on how the legalities of divorce works. As we say, a lot of people find themselves on that path, either willingly or unwillingly, but it's a difficult course to navigate at times. But thank you for giving some tips on how to handle it.
Yes, thank you for having me in.
Eva Bailey, partner of Anderson's Solicitors.